Hello everyone, this is day 59 of Polity Daily Drill. Let's begin. First question. Consider the following statements regarding Article 21 of the Indian Constitution, which deals with the protection of life and personal liberty. The doctrine of due process of law as interpreted in the United States Constitution has been explicitly incorporated into Article 21 by the Indian judiciary. Now see, this is correct that the Indian judiciary has interpreted Article 21 to also include not just procedure established but also due process of law. But it has not been incorporated into Article 21. Point 1. And point 2, judiciary has no right to modify the words in the constitution. Judiciary can only interpret the constitution. Any modification would require a constitutional amendment or an interference from the parliament. So 1 is wrong. Number 2. Article 21 is available to both citizens and non-citizens, ensuring protection to any person residing in India. Absolutely correct. There are only 5 fundamental rights available to citizens only: 15, 16, 19, 29 and 30. All other fundamental rights are meant for both citizens and non-citizens. Number 3, the right to health, including access to emergency medical treatment, has been recognized as an integral part of Article 21 by the Supreme Court of India. Yes, of course, right to health, including access to emergency medical aid, right to timely medical treatment, etc., have been incorporated or have been rather interpreted as an integral part of right to life and liberty by Supreme Court in various cases. So 2 and 3 are correct. How many statements are correct? B. Only 2 statements. Moving on to the second question. In polity, gerrymandering refers to manipulation of electoral district boundaries to favor a particular political party or group, practice of conducting public opinion polls to influence voter behavior, the act of limiting the number of terms a politician can serve in office, or D, organizing a political rally to garner support for a candidate. So B, C and D are completely baseless and irrelevant. A is the answer. Gerrymandering primarily refers to the practice of manipulating the boundaries of electoral districts to favor a particular political party, group or incumbent. This is typically done to create an advantage for the manipulating party by concentrating or diluting the voting power of certain demographics or political opponents, thereby affecting election outcomes. This term is derived from a combination of the name of, the Massachusetts governor Elbridge Gerry and the word salamander, after district he redrew in 1812, if I'm not wrong, and this was said to resemble the shape of a salamander, and hence gerrymandering, combination of his name E. Elbridge Gerry and salamander. Anyway, so A is the answer. Moving on to question number 3. Which of the following statements related to the different writs is or are correctly matched? Mandamus, this writ is meant to oust persons who are not legally qualified from substantive public posts. This is not mandamus, this is actually quo warranto. This is wrong. Quo warranto, the main objective of this writ is to keep the public authority within the purview of their jurisdiction while performing public duties. Again, this is the writ of prohibition, so this is also wrong. Number 3, certiorari. The court quashes or declares invalid a decision taken by the inferior authority or court. Absolutely correct. This is what is certiorari. So how many of the above statements are correct? So only 1. A is the answer. Moving on to question number 4. With reference to preventive detention, consider the following statements. The Parliament has the sole authority to make a law on preventive detention for reasons connected with the maintenance of public order. Now see, we all know very well that Parliament does not have the sole authority. Why? Because the topic preventive detention is under union list entry number 9. It is also in the concurrent list entry number 3. However, the statement is more specific. It says connected with the maintenance of public order. So see, as far as the provision is concerned, both the parliament as well as the state legislatures can concurrently make a law on preventive detention for reasons with security of the state, maintenance of public order, or the maintenance of supplies and services of essential commodities, that is the maintenance of supplies and services which are essential to the community. These three phrases are mentioned in the concurrent list. Hence, this statement is incorrect, because for public order, maintenance of public order, even the states can make laws for preventive detention. Number 2, the government can detain a person under preventive detention for a maximum period of 60 days with the special permission from the Supreme Court for further extension. See, firstly, it's not 60 days, it is 3 months. That would be in roughly 90 days. Number 1. And number 2, further extension will be granted by an advisory board, or you can call it a judicial advisory board. Why? Because the members are from the judiciary, either a serving high court judge or such judges, or they could be those people who are eligible to become high court judges, or of course retired high court judges as well, not the Supreme Court. So 2 is also wrong. Which statement is correct? D, neither 1 nor 2. And the last question for today. Consider the following statements regarding the anti-defection law in India. It was introduced by the 55th Amendment to the Constitution and is encapsulated in the 10th Schedule. 10th Schedule, absolutely correct. But was it introduced by the 55th Amendment? No. It was introduced by the 52nd Amendment. 55th Amendment was of 1986, when we gave the state of, or Arunachal, the status of a state from a UT, and there was a special provision added, Article 371H for Arunachal Pradesh. That is the 55th Amendment. Anyway, that's of no concern to us. The ADL was through the 52nd Amendment Act of 1985. So 1 is wrong. Number 2, the law allows for a legislator to be disqualified if their party has removed them, even if they have not voluntarily given up their membership in the party. This is wrong. If the legislator gives up his membership or votes against the party directions, only then will he or she come under the provisions of ADL vis-a-vis disqualification. If the party throws somebody out, they are not to be disqualified. They have not given up the membership. The party has thrown them out. They have done nothing wrong. So 2 is incorrect. Number 3, a party can merge with or into another party if at least 2/3 of its legislators agree to the merger without facing disqualification. Absolutely correct. Since 2003, through the 91st Amendment Act, this modification was made where splits are no longer to be recognized, but mergers, and not 1/3 but 2/3. So 3 is right, 1 and 2 are wrong. How many statements are correct? A, only 1 is correct. This brings us to an end of our discussion today. Let's meet tomorrow. Till then, that's all for me. Jai Hind.